Hey, folks, and welcome to the last ever Trump trials and tribulations. We have brought the team back together, and I know it's the last one ever because, 10 days from now, the president is going to be sworn in, and you can't have a criminal trial against a sitting president or a criminal proceeding against a sitting president. So, for at least the next 4 years, there will not be any trials and tribulations except perhaps of the people who tried to bring cases against Donald Trump. But today we have one more. Donald Trump was sentenced this morning in a courtroom in Manhattan in front of Justice Juan Merchan. He was not present. He appeared on a screen with his lawyer, Todd Blanche, and we got a million things to talk about it all. So, Tyler, get us started. Set the scene. Uh, First of all, how was the line?
The line was robust. We weren't sure how to play it, I think. It was cold, which is a factor maybe against a line. But the line dudes were out in force. Where there's a line, there are line dudes if you're in New York. Um, there was quite a crowd. I mean, it was a lot of familiar faces. But a few things, so a lot of it felt familiar, but a few things were different. Um, I think most notably, for at least for the press, was that we breezed right in. There was minimal security, which was a joy. There were no magnetometers. We just
And that was because,
That was because there was no Donald Trump. There was no Secret Service.
and
Uh,
and the New York folks don't really care if you do violence to other people in the court.
Apparently not. Apparently they're only concerned with the physical security and well-being of the president-elect, not anyone else. And so we just breezed right in with our bags full of metal weapons. Just kidding. And it was also the Trump's virtual appearance also led to a few surreal moments. I think the funniest one for me was when the pool photographers came in, as they normally do in the beginning. They snapped away at the prosecution table, the defense table, at which only one lawyer was sitting, Emile Bovy. And then they sort of awkwardly turned to the screen on which Trump and defense counsel Todd Blanche were perfectly framed and snapped photos at the little TV screens, which made for just a very surreal scene. Um,
Pictures
and then
pictures of Trump.
and then we got underway. But Anna, is there any other atmospheric color that I'm missing here?
I mean, I was just really happy I didn't get pushed into a stairwell while the Secret Service was clearing the hallway for Trump's arrival. So that was a plus for sure. But I mean, look, in terms of atmospherics amongst members of the media, it was very much felt a little bit like back to school because there are many of us who have not seen each other in 6+ months because this sentencing has been put off and put off and put off. And so that was nice, but it was one of the that's just kind of not necessarily relevant to the substance of the proceedings, but it was a kind of nice atmosphere amongst members of the press who were mainly the people who were there. There were very few members of the general public there, which was very different from the trial.
All right. Half an hour, 32 minutes, of which I think probably a couple minutes were people reading the probation report in silence. So we can say 28, 29-minute hearing at which three things happened. First, Mr. Steinglass spoke for the prosecution. Then, I guess, four things. Then Todd Blanche spoke for Donald Trump. Then Donald Trump spoke himself. And then Juan Merchan pronounced sentence. So let's just take them in order. Anna, what did Mr. Steinglass have to say?
So actually, I'm going to hand this one off to Tyler because he's been writing about what Mr. Steinglass had to say most recently. So Tyler, why don't you take this one?
Sure. So Steinglass actually began. It was funny. He asked where he was supposed to stand, which seemed like he was sort of out of practice. But then he snapped right into it. He started with just a reminder why we're here, of the fact that a jury issued its guilty verdict, and then he launched into I thought quite a strong condemnation of Trump's conduct before, during, and after the trial. Especially after the trial, he said that a lot of the rhetoric, the intimidating rhetoric, a lot of the attacks against the prosecution, their families, the court, had ratcheted up since the verdict. In fact, he characterized a lot of Trump's conduct statements as direct attacks on American institutions, on the rule of law. He brought up a few of the labels that Trump has affixed to the trial, that it's corrupt, it's rigged, it's a witch hunt, it's a sham, and then, which we then later heard from Trump himself again during Trump's statement. He he didn't mince words. He was quite forceful in these condemnations, and yet he also understood the practicality of a sentence of unconditional discharge. He also brought up the respect for the office of the president. He supported. He ultimately, of course, supported and endorsed, in a way, Justice Merchan's sentence that he wanted to impose, which was unconditional discharge. But he used his moment to issue, I think, quite a stinging statement.
And what did he, I mean, what is his argument for, this was really terrible. He's intimidating the justice system. He's showing contempt for the rule of law. And yeah, let him walk free. How does he do that jump shift?
I mean, it's basically recognition that this is not a typical case. The defendant will assume the office of presidency and the protections that are afforded to it under the recent presidential immunity ruling in 10 days' time. And he, as well as Justice Merchan, felt that this was the best way to thread the needles, to give the case some sense of finality with a conviction, which opens the door to the appeals process, while also leaving Trump's ability to govern as president unencumbered. So it really seemed like this was the only way to split the baby, or whatever the weird idiom is, that this was the only path, the only way to put a sentence, or put a punctuation mark at the end of this sentence.
So I'm
Yeah,
going to ask you to speculate wildly here, but did you get the vibe from Josh Steinglass that he's won this case or lost this case?
It's a good question. I think maybe he gave this sense that he won the battle but lost the war. He brought up I think, irreparable damage that he thinks Trump's conduct during the trial has done to the perception of the rule of law, as he brought up. He brought up this chilling effect that he believes was the intention of Trump's rhetoric and the intimidation, and Trump's, I think, victory in creating this perception, and then also this reality of being above the law. So it was a very serious and solemn statement from what I heard. So I think ultimately a loss. But
What
I
do
don't
you
know.
think, Anna?
Yeah.
When he goes home tonight and has his glass of scotch, is he going to be, I mean, formally, he's won this case. Is he satisfied today, or does he feel like he, whether won the battle, lost the war, Pyrrhic victory, whatever your choice metaphor is, what do you think he's thinking?
I think that he's going home feeling defeated. I think that they probably all are. I think that, you know, had it not been for these extraordinary circumstances, the prosecution, I can't, I'm speculating. So this is not based on any solid information or anything at all. But I think hearing the way Steinglass went through all of the things, the 10 violations of this court's orders, the contempt in the other courts, the dangerous rhetoric, and the fact that it was intentional rhetoric, attacking the judge, attacking witnesses in the case, basically putting people's lives in danger, all of those kind of aggravating factors that he went through and rattled off as he was doing this before he ultimately had to stop short and say, well, the American people deserve deserve a president unencumbered by litigation. So it really did seem like it was a defeat of sorts. I can't speak to what they're all feeling, but in my view, it did not feel like a victory for the prosecution.
All right. Now it is Todd Blanche's turn. Anna, what did Todd have to say? That's Deputy Attorney General designate Todd Blanche, that is.
Future Deputy Attorney General Todd Blanche went through a lot of the same talking points that we've heard from Blanche and from Trump outside of court throughout this case. Blanche said, Your Honor, there's a lot of things that the government just said that I disagree with. He basically, made these arguments about how it was a politically motivated case. And, all of the same kinds of arguments that they've been making the whole time about how this is a case that would not have been brought against another defendant, and that there were multiple prosecutors who looked at this issue and declined to bring charges. But then he says, and we fully intend to pursue an appeal because this is the most unfair prosecution that the world has ever seen, that kind of thing. But if a sentence is going to be imposed today, then it would be our recommendation that you sentence Mr. Trump to unconditional discharge. So in that sense, they agreed with the prosecution.
Yeah. And then what about Trump himself? He addressed the court in a fashion that was, I thought, kind of interesting. I mean, it was very similar in substance to the stuff he would say in the halls when you would get pushed into the stairwell, and but it was very different in tone. And it struck me as interesting that when he's actually addressing Justice Merchan himself, he didn't talk about, you look like an angel, but you're really a demon. He was quite polite to Justice Merchan, and all the ire was directed at the prosecution team, not at the judge, where when he's talking about the case elsewhere, he really directs a lot of bile at Justice Merchan. What did Trump have to say, and what did you make of it?
Yeah, you're right. It was interesting because I mean he has been calling this the judge's case and the judge's fake charges on his social media posts. But then today he starts by, when he's given the opportunity to speak for the first time in court, he obviously had the opportunity to speak if he would have decided to testify on his behalf. He had that option. He declined to do that. But other than that, he's been talking outside in the hallways throughout the trial, but he's largely been silent throughout this trial and throughout these proceedings. And so today, when given the opportunity to speak, he first starts by kind of attacking the legal case or the legal basis for the case altogether. So he says that he claims that he wasn't the one who recorded anything in the books. He says it was accountants who did it, and everyone said that, it was perfect. But essentially, he's arguing that the prosecution is saying that he recorded legal fees as legal expenses, and in some way that is falsification of business records. He disagrees with the fact that that should be a crime. Of course, that's not an accurate characterization of the charges or the case, but that is what he first attacks. Then he starts going after Michael Cohen, one of the key witnesses in the case. He complains that
It turns out is not George Washington.
who, yes, that was one of my favorite quotes of Trump's monologue was when he complained that Michael Cohen, that he wasn't allowed to introduce evidence to discredit Michael Cohen, and he wasn't allowed to claim attorney-client privilege or advice of counsel defense. And he said instead, Michael Cohen was allowed to get up there and talk like he was George Washington, but he's not George Washington. So for anyone who didn't know,
a matter about which I think we can all agree.
So
actually.
is that a reference to the, like, if Michael Cohen had chopped down a cherry tree, he would have lied about it? I think you're giving
too much thought. Yeah.
Maybe
early American history here on the live stream.
All right.
But so
I was just going to say, I think we can all agree today is the day that Donald Trump really became president.
Apparently not, since he doesn't take the oath of office for 10 days.
But so then Ben, he what he did do though, in terms of repeating additional false claims that he has made before, or claims that don't have a basis in fact, was he finally talked not about the judge, but about Matthew Colangelo, who is one of the prosecutors who was sitting there in court. Trump has repeatedly claimed that Colangelo in some way is affiliated with or an agent of the Justice Department, and that he was kind of one of the movers behind this prosecution, and that in some way implicates DOJ being involved in this state prosecution. There is no basis for making that claim, but he again claimed that DOJ is closely involved in this. One of them is sitting right there, and he's the one who got them to move on me. And then that was kind of, it. He then summed up by saying, "I've been so unfairly treated, and I just wanted to explain that to you, Judge." He didn't mention anything about the judge himself, who is the one who publicly outside of court he's been attacking so often.
Yeah, so I'm going to ask you the same question that I asked Tyler about the Steinglass. Do you think Donald Trump seemed like he felt like he won today?
I think, I don't know that he in speaking, the way that he presented himself, I did not feel that he was presenting himself as a victor. He was painting himself as the victim, as he so often does. But I think that if there is a clear winner, if that's how we are looking at it, of today's proceedings, I mean, it is a little bit of a draw, but I think that you've got to acknowledge that this is probably the best outcome that Donald Trump could hope for. I mean, he's walking away as the president-elect with no penalty whatsoever for 34 felony counts.
I mean, the only clearer winners are America's favorite paralegals. But all right, before we go into the Byzantine procedural history of this hearing, what did Justice Merchan have to say? Tyler.
He was pretty solemn and collected as always. One interesting thing I thought that he brought up early on was he called the trial something of a paradox, in that it was, on the one hand, as soon as the doors closed, quite an ordinary, typical trial, in procedurally, in terms of the witnesses' burden of proof. I think he may have overstated this point, actually, a bit.
If that's an ordinary trial for him, he's got a wacky court.
But I took his point to mean, or I took this as a signal to say we followed the letter of the law. We followed everything correctly. This was a well-run trial. He took time to thank court staff, officers, clerks, etc. He stood out like a sort of a class act. And then he took a similar tack, I would say, to Steinglass in terms of calling out some of the conduct that he saw on the defendant throughout the trial, though to a lesser extent, him being much more buttoned up, I would say. He did make sure to disentangle the office of the president from the office holder. He said that the office of the president is afforded great protections and respect, but that doesn't necessarily mean that the office holder in this case is afforded those same protections. He said that he acknowledges there were considerable aggravating factors to consider in Trump's case, but that the presidency being the factor that overrides every other factor, which is the reason behind the imposition of the sentence of unconditional discharge. And he ended with the following line directed directly at Trump, directly at the screens. He said, "Sir, I wish you Godspeed as you assume your second term in office." And that was it.
Yeah. It was quite a striking end, actually. And I thought the point that he made, which I really thought was kind of elegantly done, was none of the presidency's trappings are a mitigating factor in what you've done. Um, they're just a factor that overrides everything else. But it was like, you know, he was sort of saying, like, don't confuse this with my not thinking that you deserve something else. Um, uh,
Eh,
and he notes that these features of the office, including the immunity, attached after the trial, and that he was entitled to none of it as a function at the time of the trial itself. So I thought he said very few words, actually. Um, it was a very spare little speech, but I thought it packed a pretty significant punch.
and just to the answer to your question of, who won? Did Trump win? Did the prosecution win? Did Merchan win? I took Justice Merchan's tone to be that at the end of the day, nobody won here. Everyone was kind of a loser.
So I gotta say, I think Merchan comes out of this looking quite good. He ran a fair trial under very difficult circumstances. He didn't try to elevate his role, and kind of be the John Sirica of this time. He's not, despite what Trump says about him, he's been very fair. And I thought this disposition, ultimately whether Donald Trump is subject to the jurisdiction of his court and in what sense is not up to him. It's up to the Electoral College as it represents the people of the several states in the electoral process. And he acknowledged that quite gracefully, I thought. So I actually think Juan Merchan comes out of this not as cool looking as America's favorite paralegals, but certainly, with a certain glow to him. All right, Quinta, let's talk about the
Wait,
procedure.
can I add one thing to that though? Is that
Sure.
if I had one criticism of how Justice Merchan handled this, which I want to acknowledge that he had a pretty impossible task to begin with. He was put in a very difficult position by the Supreme Court, for which there were few good answers. But I will say that at one point he acknowledged explicitly that there were many aggravating factors that he would have considered if he were to impose an actual sentence and didn't have this kind of overriding factor in the presidential immunity and supremacy clause issues that he's faced with. And he kind of just incorporated them into his speech. He said, I've already discussed these aggravating factors and there's no need to go into them. And that just struck me as something that no other defendant would be afforded the kind of leeway that Justice Merchan gave in this speech. I think even when I've been in sentencing hearings in the past, even when a judge ultimately decides to give someone a very lenient sentence, there's often a segment of the speech that really kind of like tries to recognize the harm that the person did, the seriousness of the crimes. And while Justice Merchan did allude to that, I don't think he really directly hit it head on. And I
No, I
think
agree with that. He definitely seemed to say, since I'm resolving this on this other stuff, everything else rounds to zero, but don't think I didn't notice it, right? And you're right, that was a decision not to say, uh, you know, wow, do you suck? Let me count the ways, but I'm resolving it on this other basis. I think that was a choice, and it was a choice consistent with his ending it by saying, I wish you Godspeed, and, as you assume your second term, which, if you were going to be cynical about, you might say he was saying, don't hurt me. All right, Quinta, let's talk about how we got here. Because until last night, it was not clear that we were going to have a sentencing today. Um, what happened over the course of the last week or so? Uh, and what more are we waiting for the wind down of the trials and tribulations?
Yeah, what a long, strange trip it's been. So the first hint, I think, that things were going to go a bit haywire came on January 5th, when Trump filed a notice of the automatic stay of criminal proceedings, or in the alternative, a motion for immediate stay directly before Justice Merchan, essentially arguing that lingering immunity issues required immediate resolution before the sentencing could take place. Just to give a brief overview of what those issues are. So Trump is kind of pointing to two related but separate issues coming out of the immunity case. One is this question of whether or not evidence of official acts was used improperly at his trial. Of course, the idea that evidence of an official act was somehow improper is something that came from the Supreme Court after the trial had already been completed. But this is an issue that he had raised before Justice Merchan, after there's a whole previous back and forth here that ends with Merchan essentially saying, no dice. And so he's arguing here, actually, you should have thrown out the verdict against me because there were, these sort of stray instances where material was used during my time in office that constitutes an official act. And therefore means that the whole thing needs to be thrown out, and that he essentially, because the immunity decision indicates the availability of interlocutory appeals to address immunity questions, that Trump should be able to appeal this issue before the sentencing. There are problems with that argument, and I'll get to them, but that's his first argument. His second argument is that somehow the idea of presidential immunity from criminal prosecution also applies to the president-elect. And so because he is the president-elect, the sentencing also should not be able to go forward. I think both of these arguments are, let's say, tendentious. I would say Bragg's office certainly seemed to think so in their responses. We can get into the details of why maybe after I traverse some of the long and winding path. But the very short version, because I don't want to go back and go through all of the back and forths, is that there's an extended back and forth between Trump and Bragg in front of Merchan. Then they go up to the First Department excuse me, I was about to say Court of Appeals, but this is New York, so it's the appellate division of the First Judicial Department. Trump goes up to there to attempt to stall things. He doesn't have any luck. There's a sort of a ping-ponging back and forth, and we end up in this extremely confusing situation where Trump is telling the Supreme Court he's appealing from the highest New York court before he even filed an appeal with that court. But the long and the short of it is that he ends up before the Supreme Court on January 5th, I think, essentially saying, hey, I need you guys to step in. There's a back and forth here. And we end up waiting yesterday, January 9th, for the court to weigh in after Bragg files his response. In this sort of situation where Trump is asking the court to grant a stay of the sentencing, there's a ticking clock because if the court doesn't weigh in, the sentencing will, of course, occur as it did this morning. But the justices didn't seem to be doing anything. And there was also a question not only on the merits of Trump's arguments, but on the matter of whether or not the justices even had jurisdiction in the first place. There's a real question about whether or not the procedural posture of the case in the New York courts had reached a point such that it was able to be appealed up to the Supreme Court. We can talk a bit about why, but I think the argument is not obvious, it's fair to say. And so we were all waiting to see what would happen. And at about 7:30 p.m., the Supreme Court ended up issuing a very short order by a 5-4 vote. So the majority was Chief Justice Roberts and Justices Kagan, Sotomayor, Barrett, and Jackson, saying, nope, we're going to let the sentencing go ahead on the grounds that, and I quote, the alleged evidentiary violations of President-elect Trump's state court trial can be addressed in the ordinary course on appeal. And, quote, the burden that sentencing will impose on the president-elect's responsibilities is relatively insubstantial in light of the trial court's intent to impose a sentence of unconditional discharge after a brief virtual hearing. Then there was a note that Justices Thomas, Alito, Gorsuch, and Kavanaugh would have granted the application for a stay, but no further explanation as to what their reasoning was. And that was all she wrote. Then we had sentencing the next morning. So it's been a bit of a procedural pinball, I guess I would say. And frankly, the Supreme Court's reasoning is still not entirely clear to me. But that's where we ended up. That's
only half the story. Let's talk for a minute about the other half, because in some ways, the more in practical terms turns on the litigation currently going on in federal courts in Florida and Atlanta than on the litigation over whether this sentencing was going to take place or not. So what's the story there and what's the status of it?
So what you're referencing, Ben, is litigation that started, of course, between before Judge Eileen Cannon in the Southern District of Florida. Trump's co-defendants in the classified documents case, against whom the case has not been dismissed, filed an emergency motion before Judge Cannon seeking to block the release of the special counsel report that is mandated to be completed by special counsel Jack Smith before he winds down his time in office. So that report, he has to write it up, hand it to Attorney General Merrick Garland, and then Garland chooses what to do with it. I believe the Attorney General has indicated he had been planning to make it public. But Nauta and Oliveira filed an emergency motion to block the release of this document. They also, the next day, filed another emergency motion before the 11th Circuit, essentially asking more or less for the same thing. And then, to all our surprise, I think it's fair to say, certainly to mine, although maybe I'm just not cynical enough, Judge Cannon granted them an injunction. Somewhat bafflingly, because it's not clear to me that she has jurisdiction over the case. And when I say that it's not clear to me, I mean that she doesn't. or at least I haven't seen any argument for why she would, given that the whole case is currently with the 11th Circuit, given the government's appeal over her ruling dismissing the case on the grounds that Jack Smith was improperly appointed. So Cannon issues this order enjoining Garland and the Justice Department from releasing, sharing, or transmitting the report or any of its information or conclusions outside the Justice Department, which is meant to last for 3 days. And so she issues this order. There's very little explanation of what her legal reasoning is. There's no attempt to address the jurisdictional question. Anna, did you want to weigh in?
I'm like kind of grinning, kind of smirking, kind of like, losing my mind just because there is no, I mean, Ben, maybe you have an idea of how there is jurisdictional bases, but like, I have no idea how she thought. I mean, it drives me up the wall to even think about it.
I mean, I am not a Fed courts expert, but I have always understood that when you issue a ruling, a dispositive ruling, like a granting a motion to dismiss, and the case goes up to the Court of Appeals, you lose jurisdiction over the case as the district judge. You have no jurisdiction save to enforce orders that have already been issued. Like if you have a discovery order or some kind of like a gag order or something, those might remain in place and you have jurisdiction to enforce those, but you don't have general jurisdiction over somebody comes in and says, hey, I don't want the Justice Department to release a report. You don't have jurisdiction over that. And so I assume that when the 11th Circuit gets around to addressing that, they will say as much. But, as Quinta's about to describe, they had an opportunity to say something like that. And
exactly.
They passed up the first one. So
I think there's also, I will say, a very good argument, or I at least have not seen any argument to the contrary of why Cannon's injunction itself, it's not clear to me that she even has the power to enjoin the distribution of the report in the way that she says, given that she says Garland can't give it to anyone outside the Justice Department. But given that we know from the Supreme Court's immunity decision that the management of the Justice Department is the exclusive and preclusive power of the president, what happens if President Biden asked Garland to hand over the report, right? Like there are all kinds of insane questions that this prompts. So to return to our story, what happens from here, there's a further back and forth, this time before the 11th Circuit, because remember, Nauta and Oliveira have also filed a motion before the 11th Circuit, where they kind of go back and forth with the government. And around 8 p.m. yesterday, the 11th Circuit issued an order denying the emergency motion from Nauta and de Oliveira, but leaving in place the injunction from Cannon. So that starts a 3-day clock ticking until the Justice Department can release a report, although it left open the option for the Justice Department to appeal separately directly from that injunction of Cannon's, which the department then did the next morning. I also think it's worth noting that yesterday there was also a separate motion filed by Nauta and de Oliveira with Cannon purporting to inform her of what they refer to as improper disclosures made by Merrick Garland to members of Congress, where Garland essentially wrote a very short letter to members of Congress saying, hello, this report exists. There's a volume 1 and a volume 2. Volume 1 is about January 6th. Volume 2 is about Mar-a-Lago. We're not going to release volume 2. But we're going to allow certain congressional committees to take a look at it. And Nauta and de Oliveira were arguing that constitutes information or conclusions that were forbidden by Judge Cannon from being distributed outside the Justice Department under the terms of the injunction, and suggest that they might be seeking contempt and sanctions for the release of that letter. And so that is where we are currently. We're waiting for the 11th Circuit to weigh in on the Justice Department appeal of Cannon's injunction. And I would not be hugely surprised if we saw more emergency litigation before the Supreme Court, trying to further block the release of the report, depending on how things pan out.
And I am normally in the position of defending Merrick Garland, but this week I'm kind of bewildered by some of his choices. Why, they've divided this report into two different reports, one of which they say they're going to release, which is the January 6th component, and the other of which they say they're not going to release because there's this ongoing case against Nauta and De Oliveira. And so they're not going to release this second volume of the report. However, the case against Nauta and Oliveira is going to last one day into the Trump administration. Maybe it will last as long as it takes Pam Bondi to get confirmed, but not a day longer than that. And so why is Merrick Garland putting the Justice Department in the position of perhaps burying this report forever, because there's no way Pam Bondi is going to be rushing to release it, in order to save for an extra few days the case against Nauta and De Oliveira? Why not just drop that case and then release the report?
You tell me.
I mean, so I think that the argument would be making Trump bear the political cost of pardoning his co-defendants or ordering DOJ to drop that case.
At the cost of nobody ever seeing the report or waiting 4 years to see the report?
Well, so there might be, okay, so this is my question that I don't know the answer to. I have seen some suggestions that it's possible that that Biden could make the report part of his presidential records, and that then later on, if those cases are actually dismissed or pardoned, that they might be subject to FOIA or in some way releasable at a later date.
I mean, they're certainly potentially subject to FOIA. Not as necessarily as presidential records, but as Justice Department records. But it would take years of litigation to get them, and you probably get them in a highly redacted form. It's a terrible outcome.
Yeah, I mean,
Nauta and De Oliveira are walking. The only question is whether we're ever going to get to see that report.
I mean, isn't it possible that there's just not a lot of new information in there? Like,
Sure.
this has been one thing that I have been wondering about, that, certainly in the January 6th case, we got a massive download of all the information, or of an enormous amount of material that wasn't available initially, thanks to court filings that stemmed from the immunity ruling. Maybe there's just not a lot of additional stuff there in the 11th Circuit case. And so the calculation is, we would be able to release a line here, a line there. That's not really of concern to us. Let's just, push forward and make Trump bear the political cost of the pardon, as Anna says.
Well,
it's hard to know.
Okay, it comes out now versus it comes out, at the end of Trump's presidency. He's president regardless. And what is I agree. On the one hand, I mean, I'm a journalist. I want the facts. I want the truth, to the extent that we can get it. But I also just am kind of, I think if you are a political actor, which anyone in the federal government is to some extent, you have to consider what's the difference between now and then in a few years if someone FOIAs it. And I don't know that those political actors are thinking that there's much of a difference at this point.
Well, I would be very surprised if they didn't acknowledge a defense. Look, I will FOIA it myself. In fact, that's my project for Monday. And I will litigate to get it if I need to.
Yes, but
you
you're a
know,
journalist, and and I want it. I want it now, and I will help you foil it on Monday.
yeah,
I, you
but
know,
look, I just think the marginal gain. I mean, actually, Quinta, we know the answer to Quinta's question, which is how much information is there to get. And the answer is there's a lot. So if you look at the difference between the um, the indictment in the January 6th case and then the 200-page factual document that they filed when they, you know, decided to bring the case, right? When they made their factual proffer, that's the difference between the information you have at trial, the information you're thinking about as a prosecutor, and the information that you include in the indictment. We have only the indictment in this in the classified documents case. There's been substantially no other information released. And so there's probably a huge amount of information about the former president's and future president's conduct. And I think we are entitled as a population to evaluate, to have that information in something like real time. And it's much more important to me than that the Justice Department gets to have a case again and force Trump to take political responsibility for pardoning Nada and De Oliveira. Anyway,
and one more thing, though, I will say that is a clear factor in this is just the posture of the case against Nada and De Oliveira. They don't want that, although it wouldn't be uh, precedent in the sense that uh, it would be like binding. I think that they just don't want that Judge Cannon special counsel decision on the books.
but it's going to be on the books unless the 11th Circuit rules between now and the 20th. It's going to be on the books.
Yeah, you're
All
right.
right. We got two questions from the audience that I want to address. The estimable Mr. Josh Knight asks, no more criminal trials. Tribulations are another matter, but what about the ongoing civil actions, E. Jean Carroll and or the state of New York as represented by Tish James? So we actually just had a Second Circuit opinion, I believe, upholding the first, which is to say E. Jean Carroll 2 decision. The first is the second, and the second is the first. This is the $5 million one, and it was affirmed. The New York State civil case against the Trump Organization had an oral argument before the first division where people seemed pretty skeptical of the judgment. So look for an opinion in that anytime. And the $80 million E. Jean Carroll case is similarly on appeal, and I have not heard that that one has even been argued yet, has it? Does anybody know?
Unfortunately, our E. Jean Carroll Trump civil fraud person, Roger, is not here. And also thanks, Josh, for always being our civil case questioner, but I don't know the answer. Sorry, Ben.
The famed anonymous attendee asks, I continue to think about Trump's attorneys in this continued undermining of the rule of law and where the boundaries are of the rules of ethics. So, the last time this question came up, um, uh, um, was fairly defensive of Blanche and Bovey and said that they had done, a very good job with a very difficult client. Um, I got some email in response to that from uh, people who had a different, more Roger Parloff-like take on it, that they had made arguments that were inappropriate. And that there were some issues with particularly Bovey's aggressiveness in the U.S. Attorney's Office. Uh, I take the point about some of the arguments they have made being inappropriate. And I don't know honestly what the line is. I do, where you have arguments that can actually help your client by delegitimizing the process. And look, 4 justices of the Supreme Court were prepared to step in to stop this this sentencing from taking place. That shows that line set kinds of arguments are actually kind of effective within the confines of the court system. Um, I agree with Roger and with the people who have written to me that the fact that, it works doesn't necessarily make it appropriate. And so I have mixed feelings about this, to be honest. Um, uh, the other thing that I will say, the matter that concerns me more at this stage is what the standards for recusal for Bovee and Blanche are going to be. Blanche in particular, although because of the hierarchy of the Justice Department, Bovee is important here too, because if the Deputy Attorney General is recused, the PADAG, the Principal Associate Deputy, does a lot of that stuff. And so, you know, what the rules are going to be when who's going to be responsible when the Justice Department has to do something and Trump gets personally involved or it bears in some way. For example, who's going to make the decision to drop the case against Nauta and Oliveira? Surely Todd Blanche can't make that decision. Uh, you know, so I think it's a really complicated set of issues, and it's not going to end now. It's going to go on.
Yeah, and can I just add to Quinta, correct me if I'm wrong, but I believe in one of the filings, maybe it was by defense counsel, but they mentioned that one of the special counsel, one volume of the special counsel's report may reference conduct that is very critical or may be very critical of conduct of defense counsel. It's unclear which defense counsel in the Trump cases, but that is, I think, one reason why it would be of great public interest to have one or both of these reports released, is because if there are findings or there's information about the conduct of defense counsel, many of whom are about to become some of the top public officials in the country, then that seems like, it would be very important for people to know, especially ahead of confirmation hearings. But Quinta, do I have that right?
I can't find the specific line that you're referring to, but I believe you are correct.
Yeah, so I think it's a complicated subject, and I will say, Tyler and Anna and I all sat through the entire trial, and I I thought, as a general matter, that conduct of defense counsel was in the main appropriate. There are lots of things in briefs that Roger has pointed out to me that I agree are arguments that, shouldn't be made. They're just kind of conspiracy theories about the prosecution, about relations between the Justice Department and but the conduct of the trial as a general matter, I thought was fine, honestly. And I thought actually Emile Bovee's performance was superb, with a bad hand, by the way, because the evidence against the president was pretty substantial. And so, and that's different, honestly, from the behavior of some of his other lawyers in some of the other cases, where, they're outrageous and they get people disbarred. No one's going to get disbarred in this. No one's going to have a substantial bar complaint against them, notwithstanding the criticism that Anna refers to. So I just think, it's a complicated picture. He's an extraordinarily difficult client. And, at the end of the day, their job was to keep him out of jail, and they did it. Um, all right, we got one more question, and then I'm going to go around for final thoughts. Matt asks, could Judge Merchan not have imposed a fine on Trump, or would he not bother simply because the amount would be so small? Anna, Tyler, I know you guys have a rip-roaring answer to this question.
Tyler,
Well, I can't claim finding this on my own. An eagle-eyed observer on Blue Sky and X pointed this out, but he actually did have to pay $375. $50 of that was for a DNA database fee. The remaining $325 was for a
Wait,
crime
he's
victim.
in the DNA database now?
I that's what I took it to mean. I believe so.
So does that mean, like, if there's a cold case that matches his DNA, we're going to have, like, 3 months from now, it's going to turn out that that actually he did the Central Park jogging attacks?
You're giving certain people too much hope, I think, with this wild conspiracy theory. But
Yeah,
and
just
then
to be
I will
clear,
just say
that
also,
was a joke.
yes,
There is no factual basis for that, although there's about as much as there was for the allegations he made on the subject.
And then I'll briefly just say the other 325 was for a mandatory surcharge and a crime victim assistance fee.
All right, guys, final thoughts. Quinta.
I was hoping you would go to me last so I would have some time to collect mine. I mean, look, at the end of the day, I will say I think this is a real I think that the New York criminal justice system comes out looking the best in all of the various Trump cases. This Carroll case, or excuse me, strike that. There are too many cases. This hush money case was one that I think was really not taken seriously, in part because the U.S. Attorney's Office for the Southern District of New York declined to pursue it. There was a lot of very dismissive language flying around about it when Bragg finally decided to move forward. And it was the one that made it through. And I think that what that shows, and also I should say, the DA's office, as far as I can tell, and from the few days that I spent up there watching the trial, did an extremely professional job prosecuting it. Justice Merchan did, as well as he possibly could have done, balancing extremely complicated legal and political situation. And if you compare that to the Georgia case, which has just been a real trash fire, to use a technical term, and the federal cases, which I think were, at least in the January 6th case, was too little too late. I think that this is a real indication that prosecutors could and should have pushed faster and harder to bring these charges. In the end, at the end of the day, yes, Trump got off with unconditional discharge and a small fine. But I do think that it matters that, a jury of his peers voted unanimously that he had committed these felonies. And it's a real travesty that we didn't get to that stage in at least the other two federal cases.
Anna.
So one thing that I will say is that we're calling this I think we called this the last Trump trials and tribulations, but Trump's team has vowed to appeal. And one thing I will say about
Those aren't trials.
Oh, well,
that's Trump appellate law and
and
tribulations. It's a different
appeals
series.
Okay. Appeals and tribulations, post-trial tribulations. So Trump's team has vowed to appeal. One thing that we didn't mention about the stay order in which the Supreme Court declined to stay the sentencing in a 5-4 decision, that indicates to me that when the post-conviction appeal eventually goes up to the Supreme Court, there are 4 justices who would grant cert on the question of whether or not the evidence that was admitted was improperly admitted and that Trump's conviction should be thrown out. Maybe that's an overreading of the fact that 4 of the justices would grant the stay, but I don't think it is. And so there will be more on what happened in this case, but I, to some extent, I think agree with Quinta that, I went into that trial myself not entirely sure what I made of the legal and factual basis of the charges in New York, and came out of it being convinced that it was a strong case. And I think that the people who did not sit through that trial are not the best position to speak on it. And so I would encourage some reflection from those people who have made many conclusions about the case without having actually sat through it. But
yeah, I agree with that. I think there's a huge difference in attitude toward this case between people who watched it and people who only read it or read about it, particularly in punditry early in the proceedings. Tyler, bring us home. You get the last word today.
I suppose you're not going to let me give the old line that the Chinese premier gave when asked about the French Revolution, that it's too early to say. So instead of that, I will say I share Anna's journalistic inclinations here that more information, more facts are better. And the trial unearthed quite a lot of facts and stories about Trump's conduct, his associates' conduct in the lead up to the 2016 election. And we got that information out there before the 2024 election. The public looked at the information and decided to reelect Trump anyway. But I still think it was good to at least get it out there for now and for posterity. But I am still turning it over in my head over and over.
We will continue to turn it over and over in our heads, even if our heads look like this. Um, we're going to leave it there, though. Lawfare Live is not ending. We're going to do Lawfare Live regularly. We just did one on the TikTok case, by the way. If you haven't seen the oral arguments in the TikTok case and you want to check out a really good discussion of that, we're going to continue doing Lawfare Lives. But the Trump Trials and Tribulation series is now for the 2nd time ended. And maybe we'll end it for the 3rd time sometime in the near future. Keep the faith and keep reading, and we will